So I think I'll start off by talking about why family courts are becoming more transparent. So currently in England, they have launched a transparency pilot scheme that started initially in Leeds, Cardiff and Carlisle, but it's now been extended, I think it was in January 2024, to 16 additional other courts in and across England, and it applies to both public and private law family cases. The point of this transparency pilot scheme is to allow accredited media and legal bloggers to report on family court cases, but it's subject to strict rules of anonymity. So the aim of the transparency pilot scheme is to increase transparency in family court proceedings to enhance public confidence and understanding. However, the ability to report is being piloted to make sure it can be done safely and with minimum disruption to those involved in these cases, within the court. And this will be done through judges in these courts making a transparency order which sets out the rules of what can and cannot be reported. And I guess as the family courts in England and Wales are becoming more transparent, you then see a dual impact on privacy and the use of ADR, which is alternative dispute resolution. So firstly, people going through a divorce are going to have significant privacy concerns, as alarm bells are going to ring whereby they think that possibly sensitive and personal or financial information could become more publicly accessible. And for instance, I guess in financial proceedings, it could be that this exposure might actually deter some individuals from disclosing their assets, and it could then complicate a fair settlement. Or on the other hand, in children proceedings, the challenge lies in balancing transparency with the need to protect the identities and personal information of the children. In response to these privacy concerns, I do anticipate a rise in the use of ADR, alternative dispute resolution methods. I think the methods offer a more private and relaxed setting, and sometimes even a quicker resolution compared to the traditional court proceedings. For instance, in financial disputes, I think you'd possibly see a rise in arbitration, resolving those financial complex issues privately. So what arbitration is that arbitration involves appointing an independent arbitrator, typically a trained solicitor or barrister, to adjudicate a dispute or issue arising from a family breakdown. And this can include financial issues or child arrangements, and the arbitrator's decision will be legally binding, like how a court's decision is legally binding by a judge. I think potentially in children proceedings, mediation might be an option. It can allow for more flexibility, and again is somewhere where they can have confidential negotiations. And I haven't actually told you what mediation is. Mediation is a voluntary and confidential process where a neutral, professionally trained mediator assists those going through divorce or separation. There's also what's called early neutral evaluation, which I think is an up-and-coming thing, which could be used for either financial disputes or children arrangements. But I think what everybody needs to be considering with all these scenarios of ADR is that you need to consider the most suitable option for those involved all the time, and you need to take into account any safeguarding concerns and other specific issues that might make those options unsuitable for the parties involved. I think that whilst increased transparency in family courts aims to build public trust, it also needs to necessitate a careful balance to protect the individual's privacy. And with the rise in ADR methods offering viable alternatives for those seeking to resolve disputes privately, I do think that the transparency pilot scheme is a significant step towards achieving the balance and ensuring that the family court system remains both transparent but respectful of privacy.